Today's episode of Coffee with Lynn is an interview with Jessica Showers. She is an estate planning attorney with Hammond Law Firm. Jessica, thank you for joining me today.
Thank you, Lynn.
As a real estate broker, I come across a lot of clients who have a situation where they have to sell property that belongs to a relative. What should you tell people like that? What is important for them to know?
It's a good question. So in a couple of instances, there are different things we're going to need. So if they're selling property for their relative and it's for a mom, let's say, and she's incapacitated, they're going to need a document that gives them the legal authority to actually sell the property. So they're going to want to look for a financial or property power of attorney that says, yes, daughter, you are the one who I want to be my agent and sell my property for me. So it's important to have that piece of paperwork. If they don't have that, if mom doesn't have a financial or property power of attorney, they're going to need to get a court order from the court, from the judge, that says that they are the person's guardian and or conservator, giving them the legal authority to manage their assets and to make those types of decisions for their parent or relative who's incapacitated. Now, in a situation where the mother or relative has passed away, then what we're looking at is trying to figure out if they had a will or some sort of written instruction as to how they want to see their assets distributed. Assuming they have a will, they've hopefully written down who they want to be their personal representative, or sometimes referred to as executor, who's going to administer their estate for them when they've passed away. So, person who wants to sell the home needs to get the original will or a copy, if they have it. The original is always better, that says, yes, you're the personal representative. They then submit that will to the court for probate, and the probate court will issue them something known as letters of testamentary. And those letters give them the authority to sell the property for their relative, and then distribute those proceeds in accordance with the wishes in that person's will.
I'm seeing more transactions where the buyer and the seller are a trust. Can you explain why it's important to have a trust and what are the benefits of a trust?
So we see a lot of people now using a planning tool called a revocable living trust. It allows us to create basically an empty box that we can then put our assets into. So when you have a client who is selling their home and it's in the name of the Smith Living Trust, that's what they've done. Their trust has specific instructions as to who's going to manage the asset, who's going to sell it when they are no longer using it, whether they're incapacitated or passed away. So there's no need for court involvement because the trust already tells us who's going to be the person who can sign off on the sale and who can then distribute those assets as necessary. And the trust itself will say, yes, this person can sell my property or buy new property for me, depending on what powers are in the document. So it's always a great idea when you're working with a client to make sure that you have that trust document so that you know what they can or can't do. So that's one of the big benefits of a trust, is that it allows families to take care of those transactions without needing court involvement. They don't have to wait for a judge to give them permission. They can just follow the instructions in the trust, which is really the permission from the owner saying, yes, it's okay with me if you do this if I've passed away or become incapacitated.
So it sounds like a revocable trust takes care of a situation where the family has to dispose of the property.
It can certainly clarify it for people and can make sure that, yes, we know this is the person who has the authority. Most importantly, that person who's named in the trust doesn't have to wait for a judge to give them more authority. Whereas with a will, yes, it says this is the person I want to be my personal representative. I want it to be my son or daughter. But your son or daughter is still going to have to go to court and get that final letter from the judge saying, yes, we got mom's will. We agree with mom's determination. We're going to go ahead and give that authority to son or daughter as outlined in the will.
Great. Thank you so much. I know there's a lot more information, so if people want to get a hold of you to ask more questions, how do they reach you?
Best way to do that is our office line, 719-520-1474. We're here to answer questions that people may have.
Well, there's a lot more to know about estate planning. If you need more information, contact Jessica Showers at the Hammond Law Group. Call the number on the screen that you see below. And join me on my next episode of Coffee with Lynn.